Good morning, everyone. Now, let's start with the sixth chapter Citizenship. It is from the series of Laxmikant audiobook. So, let's start with the chapter number 6 Citizenship, Meaning and Significance. Like any other modern state, India has two kinds of people citizens and aliens. Citizens are the full members of the Indian state and owe allegiance to it. They enjoy all civil and political rights. Alien, on other hand, are the citizens of some other state and hence do not enjoy all the civil and political rights. There are of two categories friendly aliens or enemy aliens. Friendly aliens are subject of those countries that have cordial relation with India. Enemy aliens, on other hand, are subject of that country that is at war with India. They enjoy lesser rights than the friendly aliens. For example, they do not enjoy protection against arrest and detention, which is in Article 22. The Constitution refers to the following rights and privileges on the citizens of India and denies the same for aliens. First, right against discrimination on the grounds of religion, race, caste, sex, or place of birth. Article 15. Second, right to equality of opportunity in the matter of public employment. Article 16. Third, right to freedom of speech and expression, assembly, association, movement, residence, and profession. Article 19. Fourth, cultural and educational rights. Article 29 and 30. Fifth, right to vote in the elections to the Lok Sabha and Legislative Assembly. 6. Right to contest for the membership of the Parliament and the state legislature. 7th, right eligibility to hold public offices, certain public offices, that is, President of India, Vice President of India, judges of Supreme Court and High Courts, Governor of States, Attorney General of India, and Advocate General of States. Along with the above rights, the citizens also owe certain duties towards the Indian state, as for example paying taxes, respecting national flag and national anthem, defending the country, and so on. In India, both a citizen by birth as well as a naturalized citizen are eligible for the office of president, while in USA only citizen by birth and not neutral naturalized citizen is eligible for the office of president. Constitutional provisions. The constitutions deal with the citizenship of Article from Article 5 to Article 11 under the part 2. However, it contains neither the However, it contains neither any permanent nor any elaborate provisions in this regard. It only identifies the person who became citizen of India at its commencement, that is, at 26 January 1950. It does not deal with the problem of acquisition or the loss of citizenship. Subsequent to its commencement, it empowers the Parliament to enact the law to provide for such matters and any other matter relating to the citizenship according to the Parliament. Accordingly, Parliament has enacted the Citizenship Act of 1955, which has been amended from time to time. According to the Constitution, following four categories of the person became citizen of India at its commencement, that is on 26 January 1950. First, a person who had his domicile in India and also fulfilled any one of the three conditions, viz. If he has born in India, or if either of his parents were born in India, or if he has been ordinary resident of India from past 5 years immediately before the commencement of 5 years immediately before to the commencement of constitution became the citizen of India. Second, a person who is migrated to India from Pakistan became an Indian citizen if he or either of his parents or any of his grandparents was born in undivided India and also fulfilled any one of the two conditions, viz. In case he migrated to India before July 1948, he has been ordinary resident in India since the date of his migration, or in case he migrated to India or after 19 July 1948, he had been registered as a citizen of India, but the person could be so registered only if he had been resident of India for past 6 months preceding to the date of application of registration. A person whom is migrated to Pakistan from India after March 1, 1947, but later returned to India for the resettlement could become an Indian citizen. For this, he had to be resident of India for 6 months preceding to the date of his application for the registration. Fourth, a person who or any of whose parents or grandparents were born in undivided India but who is resident ordinarily residing outside the India shall become Indian citizen if he has been registered as a citizen of India by diplomatic and consular representative of India in the country of his residence, whether before or after commencement of the Constitution. Thus, this provision covers the overseas Indians who may want to acquire Indian citizenship. To sum up, all the provisions deals with the citizenship of first, person domiciled in India, second, persons migrated from Pakistan, third, persons migrated to Pakistan but later returned, and fourth, persons with Indian origin resides outside India. The other constitutional provision with respect to the citizenship as follows. First, no person shall be a citizen of India or deemed to be citizen of India if he has voluntarily acquired the citizenship of any foreign state. Second, every person who is deemed to be citizen of India shall continue to such citizen subject to the provisions of any law made by Parliament. Third, Parliament shall have power to make the provisions with respect to the acquisition and the termination of citizenship and all other matters relating to the ownership, relating to the citizenship. Citizenship Act of 1955. The Citizenship Act of 1955 provides for the acquisition and loss of citizenship after the commencement of the Constitution. Originally, the Citizenship Act of 1955 also provided for the Commonwealth citizenship, but this provision was repealed by Citizenship Amendment Act of 2003. Acquisition of citizenship. The Citizenship Act of 1955 prescribes 5 ways of acquiring citizenship, viz. Birth, descent, registration, naturalization, and incorporation of territory. First, by birth, a person born in India or on after January 26, 1950 but before July 1, 1987 is citizen of India by birth irrespective of the nationality of his parents. A person born in India on or after July 1, 1987 is considered as a citizen of India only if either of his parents is a citizen of India at the time of his birth. Further, those born in India on or after December 3, 2004 are considered citizens of India if both of their parents are citizens of India or one of whose parent is a citizen of India and other is not illegal migrant at the time of their birth. The children of foreign diplomats posted in India and enemy aliens cannot acquire the Indian citizenship by birth. By descent, a person born outside India on or after January 26, 1950, but before December 10, 1992, is a citizen of India by descent, if his father was a citizen of India at the time of his birth. A person born outside India on or after December 10, 1992 is considered as a citizen of India if either of his parents is a citizen of India at the time of his birth. December 3, 2004 onwards, a person born outside India shall not be a citizen of India by descent unless his birth is registered at an Indian consulate within 1 year of the date of birth or with the permission of central government after the expiry of the said period. An application for the registration of the birth of a minor child to an Indian consulate shall be accompanied by an undertaking in the written form of the parents of such minor child that he or she does not hold the passport of another country. Further, a minor who is a citizen of India by virtue of descent and is also the citizen of any other country shall cease to be the citizen of India if he does not renounce the citizenship or nationality of the another country within 6 months of his attaining full age. Third, by registration. The central government may, on application, register as a citizen of India any person not being illegal migrant if he belongs to any of the following categories, namely a person of Indian origin who is ordinarily resident of India for 7 years before making an application for registration. B. A person of Indian origin who is ordinarily resident of in any country or place outside the undivided India. C. A person who is married to the citizen of India and is ordinarily resident in India for 7 years before making an application for registration. D. Minor children of persons who are citizens of India. E. A person of full age and capacity whose parents are registered as citizens of India. F. A person of full age and capacity or either of his parents was the earlier citizen of independent India and is ordinarily resident of India for 12 months immediately before making an application for the registration. G. A person full of age and capacity who has been registered as an overseas citizen of the India card holder for 5 years and who is ordinarily resident in India for 12 months before making an application for registration. A person shall be deemed to be Indian origin if he or either of his parents was born in undivided India or in such other territory which became part of India after the August 15, 1947. All the above categories of the person must take an oath of allegiance before they are registered as citizens of India. Fourth, by naturalization. The central government may, on application, grant a certificate of naturalization to any person not being an illegal migrant if he possesses the following qualifications. A. That he is not subject or citizen of any country where the citizens of India are prevented from becoming subjects or citizens of that country by naturalization. B. That if a citizen of any country, he undertakes to renounce the citizenship of that country in the event of his application for Indian citizenship being accepted. C. That he has either resided in India or has been in the service of Government of India or partly one and partly other throughout the period of 12 months immediately preceding the date of application. D. That during the 14 years immediately preceding the said period of 12 months, he has either resided in India or has been in the service of a government in India or partly one and partly other for the periods amounting in the aggregate to not less than 11 years. E. That he is of good character. F. That he has an adequate knowledge of the language specified in the 8th schedule of the Constitution. And G. That in the event of certificate of naturalization being granted to him, he intends to reside in India or to enter or continue in the service under the government in India or under an international organization of which India is a member or under a society, company, or the body of persons established in India. However, the Government of India may waive all or any of the above conditions for naturalization in case of a person who has rendered distinguished service to the science, philosophy, art, literature, world peace, or human progress. Every naturalized citizen must take an oath of allegiance to the Constitution of India. Fifth, by incorporation of territory. If any foreign territory becomes a part of India, Government of India specifies the persons who among the people of this territory shall be a citizen of India. If the persons become the citizen of India from the notified date, for example, when Pondicherry became the part of India, government had issued the Citizenship Pondicherry Order 1962 under the Citizenship Act of 1955. Sixth, a special provision as to the citizenship of the persons covered by Assam Accord. The Citizenship Amendment Act of 1985 added the following special provisions as to the citizenship of persons covered by the Assam Accord, which is related to the foreigners issue. A. All persons of Indian origin who came to the Assam before January 1, 1966 from Bangladesh and who has been ordinarily resident in the Assam since date of their entry into Assam and shall be deemed to be citizens of India as from the January 1, 1966. Every person of Indian origin who came to Assam on or after the January 1, 1966 but before the March 25, 1971 from Bangladesh and who has been ordinarily resident in Assam since the date of his entry into Assam and who has been detected to be a foreigner shall register himself such as registered person shall be deemed to be a citizen of India for all purposes as from the date of expiry of a period of 10 years from the date of detection as a foreigner. But intervening period of 10 years, he shall have the same rights and the obligations as a citizen of India, excepting the right to move. Loss of citizenship. The Citizenship Act of 1955 prescribes 3 ways of losing the citizenship, whether acquired under the Act or prior to it under the Constitution, viz. Renunciation, termination, and deprivation. First, by renunciation, any citizen of India of full age and capacity can make a declaration renouncing his citizenship of India upon the registration of that declaration that the person ceases to the citizen of India. However, if such declaration is made during the war in which India is engaged, its registration shall be withheld by the government. Further, when person renounces his citizenship, every minor child of that person also loses the Indian citizenship. However, when such a child attains the age of 18, he may resume the Indian citizenship. Second, by termination. When an Indian citizen voluntarily, consciously or unconsciously, knowingly, and without duress, undue influence, or compulsion, acquires the citizenship of another country, his Indian citizenship automatically terminates. This provision, however, does not apply during a war in which India is engaged. Third, by deprivation. It is compulsory termination of India's citizenship by central government if the citizen has obtained the citizenship by fraud. The citizen has showed disloyalty to the Constitution of India. The citizen has unlawfully traded or communicated with the enemy during the war. The citizen has, within 5 years after the registration or naturalization, been imprisoned in any country for 2 years. E. The citizen has been ordinarily resident out of India for 7 years continuously. Single citizenship. Though the Indian Constitution is federal and envisages a dual polity, center and state, it provides for only a single citizenship, that is the Indian citizenship. The citizens in India owe allegiance only to the Union. There is no separate state citizenship. The other federal states like USA and Switzerland, on the other hand, adopted the system of double citizenship. In USA, each person is not only a citizen of USA but also of a particular state to which he belongs. Thus, he owes the allegiance to both and enjoy the dual sets of rights, one set confirmed by the national government and another by the state government. This system creates a problem of discrimination. That is, a state may discriminate in the favor of citizens in the matter like right to vote, right to hold public offices, right to practice professions, and so on. This problem is avoided in the system of single citizenship prevalent in India. In India, all citizens, irrespective of the state in which they are born or reside, enjoy the same political and civil rights of citizenship all over the country and no discrimination is made between them. However, the general rule of absence of discrimination is to subject to some exceptions. Viz. First, the Parliament under Article 16 can prescribe residence within a state or union territory as a condition for certain employments or appointments in that state or union territory or local authority, other authority within that state or union territory. According to the Parliament enacted the Public Employment Requirement as to the Residence Act of 1957 and thereby authorized the Government of India to prescribe the residential qualification only for the appointment to non-gazetted posts of Andhra Pradesh, Himachal Pradesh, Manipur and Tripura. As this act expired in 1974, there is no such provision for any state except the Andhra Pradesh and Telangana. Second, the Constitution under Article 15 prohibits the discrimination against any citizen on the grounds of religion, race, caste, sex, or place of birth, and not on the ground of residence. This means that the state can provide the special benefits or give preference to its residents in the matters that do not come within the purview of the rights given by the Constitution to the Indian citizens. For example, a state may offer concession in the fees for education to its residents. Third, the freedom of movement and residence under Article 19 is subjected to the protection of interests of any scheduled tribes. In other words, the rights of outsiders to enter and reside in and settle in the tribal areas is restricted. Of course, this is done to protect the distinctive culture, language, custom, and manners of the scheduled tribes and to safeguard their traditional vocation and the property against exploitation. Till 2019, the legislature of erstwhile state of Jammu and Kashmir was empowered to a. Define the person who are permanent residents of the state. B. Confer any special rights and privileges on such permanent residents as respects. First, employment under the state government. Second, acquisition of immovable property in the state. Third, settlement in the state. And fourth, rights to scholarships and other forms of aid provided by the government. The above provisions was based on Article 35A of the Constitution of India. This was inserted in the Constitution by the Constitution Application to Jammu and Kashmir Order 1954. This order was issued by the President under Article 370 of the Constitution, which had provided a special status to erstwhile state of Jammu and Kashmir. In 2019, the special status was abolished by the new presidential order known as the Constitution Application to Jammu and Kashmir Order 2019. This order superseded the earlier 1954 order. The Constitution of India is that of, like Canada, had introduced the system of single citizenship and provided uniform rights, except in a few cases for the people of India to promote the feeling of fraternity and unity among them, and to build an integrated Indian nation. Despite this, India has been witnessing the communal riots, class conflicts, caste wars, linguistic clashes, and ethnic disputes. Thus, the cherished goal of the founding fathers and the constitution makers to build an united and integrated Indian nation has not been fully realized. Overseas citizenship of India. In September 2000, the Government of India, Ministry of External Affairs, had set up a high-level committee on Indian diaspora under the chairmanship of L.M. Singhvi. The mandate of the committee was to make the comprehensive study of the global Indian diaspora and to recommend the measures of constructive relationship with them. The committee submitted its report in January 2002. It recommended the amendment of Citizenship Act 1955 to provide for the grant of dual citizenship to the persons of Indian origin (PIO) belonging to the certain specified countries. Accordingly, the Citizenship Act Amendment Act of 2003 made provisions for the acquisition of overseas citizenship of India (OCI) by the PIOs of 16 specified countries other than the Pakistan, Bangladesh. It also omitted all provisions recognizing or relating to the Commonwealth citizenship from the Principal Act. Later, the Citizenship Amendment Act of 2005 expanded the scope of grant of OCI for PIOs of all countries except Pakistan and Bangladesh as long as their home countries all dual citizenship under their local laws. It must be noted that the OCI is not actually a dual citizenship as the Indian Constitution forbids dual citizenship or dual nationality under Article 9. Again, the Citizenship Amendment Act of 2015 has modified the provisions pertaining to OCI in the Principal Act. It has introduced a new scheme called Overseas Citizen of India Card Holder by merging the PIO card scheme and the OCI card scheme. The PIO card scheme was introduced in the August 19, 2002 and thereafter the OCI card scheme was introduced with the effect from December 2, 2005. Both the schemes were running in the parallel even though the OCI card scheme had become more popular. This was causing unnecessary confusion in the minds of applicants, keeping in the view some problems being faced by the applicants and to provide the enhanced facilities to them, the Government of India decided to formulate one single scheme after the merging PIO and OCI schemes. containing the positive attributes of both. Hence, for achieving this objective, the Citizenship Amendment Act of 2015 was enacted. The PIO scheme was rescinded with effect from the January 9, 2015, and it was also notified that all existing PIO holders shall be deemed to be OCI card holders with effect from January 9, 2015. The Citizenship Amendment Act of 2015 replaced the nomenclature of Overseas Citizen of India with that of the Overseas Citizen of India card holder and made the following provisions in the Principal Act. First, registration of Overseas Citizen of India card holder. The central government may, on an application made in this behalf, registered an overseas citizen of India card holder. A. Any person with the full age and capacity who is citizen of another country but was the citizen of India at the time or at any time after the commencement of the Constitution, who is the citizen of another country but was eligible to become the citizen of India at the time of the commencement of the Constitution, or who is the citizen of another country but belonged to the territory which became the part of India after August 15, 1947, or who is the child or grandchild of a great or great grandchild of such, or B. A person who is a minor child of the persons mentioned in Clause A, or C. A person who is the minor child and whose both parents are the citizens of India, or one of the parent is citizen of India, or D. The spouse of foreign origin of citizen of India or the spouse of foreign origin of an overseas citizen of India card holder and whose marriage has been registered and subsisted for a continuous period of not less than 2 years immediately preceding the presentation of application. No person who are either of whose parents or grandparents or great grandparents is or had been a citizen of Pakistan, Bangladesh, or such country as a central government which may specify shall be eligible for the registration as an overseas citizen of India card holder. Second, the central government may specify the date which existence person of the Indian origin card holder shall be deemed to be the overseas citizen of India card holder. 3. Notwithstanding anything contained in the point 1, and the central government may, if it is satisfied that the special circumstances exist and according to the circumstances in writing, the register a person as an overseas citizen of India card holder. Second, the conferment of the citizen rights on the overseas citizen of India card holder. First, an overseas citizen of India card holder shall be entitled to such rights as the central government may specify in this behalf. Second, the overseas citizen of India card holder shall not be entitled to the following rights which are conferred on the citizen of India. He shall not be entitled to the right to equality of opportunity in the matters of public employment. He shall not be the eligible of the election as a president, vice president. He shall not be the eligible for the appointment as a judge of Supreme Court and judge of High Courts. He shall not be the entitled for the registration as a voter. He shall not be the eligible for being the member of House of People or the Council of States. He shall not be eligible for being the member of State Legislative Assembly or State Legislative Council. He shall not eligible for the appointment to the public services and the posts in connection with the affairs of union or any of the state, except for the appointment in such services and posts as a central government may specify. Third, Renunciation of overseas citizenship of India card. First, if any overseas citizen of India card holders make the prescribed manner a declaration announcing the card registering him as the overseas citizen of India card holder, the declaration shall be registered by the central government, and upon such registration that person shall cease to be the overseas citizen of India card holder. Second, where the person ceases to be the overseas citizen of India card holder and the spouse of the foreign origin of that person who has obtained the overseas citizen of India card, and every minor child of that person registered as the overseas citizen of India card holder shall thereupon cease to be the overseas citizen of India card holder. Fourth, the cancellation of registration as the overseas citizen of India card holder. The central government may cancel the registration of the person as an overseas citizen of India card holder if it is satisfied that the registration as an overseas citizen of India card holder was obtained by the means of fraud, false representation, or the concealment of any material fact. B. The overseas citizen of India card holder has shown disaffection towards the Constitution of India, or the overseas citizen of India card holder has during any war in which the India may be engaged unlawfully traded or communicated with an enemy, or the overseas citizen of India card holder has within 5 years after the registration been sentenced to the imprisonment for a term of not less than 2 years, or it is necessary so to do in the interest of sovereignty and integrity of India, the security of India, friendly relations of India with any foreign country, or in the interest of general public, or if the marriage of an overseas citizen of India card holder has been dissolved by the competent court of law or otherwise, or has been not dissolved but during the subsistence of such marriage he has solemnized a marriage with any other person. Here we complete with the chapter number 6, the citizenship of India. Please refer to the table 6.1 and 6.2 from the book. If you at all find this audiobooks helpful anywhere during your preparation for the any examinations, then please do not forget to like and share our videos, and don't forget to subscribe to this channel for more such content. Thank you. Have a good day.